is a departmental order sent to another department, and therefore there is no rights and obligations of Electramart which is violated with specific to that order. So the very challenge on what basis Electramart is challenging such an order is the question. When we look at the case of CCI versus SAIL, which is a landmark judgment, when we look at Competition Act, it has clearly stated the parallel provision in Competition Act is 26 subclause 1, where similarly Commission will advise. Commission will, looking at their prima facie opinion, advise DG to conduct an investigation. One such investigation has to be conducted. Thus, very order which says that an investigation has to be conducted cannot be challenged, and Electramart has challenged that very order.
Are you trying to suggest that against an order holding that there is a prima facie case made out, no challenge is permissible under law?
Your Lordship, there can be a challenge when there are reasons not recorded in prima facie.
When appeal lies perhaps against that order, against the order holding that there is a prima facie case.
No, Lordship, according to section 4.
Appeal doesn't.
No. That is the entire allegation, Your Lordship. That section 34, when it gives certain list of appeals with regards to orders passed with respect to certain provisions, that does not contain 16 subclause 1, rather it contains 16 subclause 2, where such proceedings has been closed by the CCI.
But which jurisdiction still continues to lie? Which jurisdiction lies?
The which jurisdiction lies for that? I'll go into the matter of the merits of the case, Your Lordship. When we say that Electramart, the prima facie order says that Electramart has failed to submit a report under section 9, hence violating its obligation. Under section 9, it was obligated to Electramart to file a report stating that what all measures have been taken in order to comply with the obligations. The council will take just 2 more minutes to conclude their argument. Your Lordship, when we look at the violation of section 12 subclause 2, it says that the very nature in which the privacy policy exists of Electramart is in the nature of take it or leave it, where it asks consent of their users in a manner where they are required to give unconditional and very broad consent, which is not in consonance when we look at section 6 of Digital Personal Data Protection Act, DPDP Act, where it says that the consent should be specific. They have stated the consent is with respect to certain things such as name and address, but it is not limited to such name, address and other details of its users. Further, Your Lordship, such blanket clauses of user consent without proper disclosure will lead to will constitute a breach of competition law in digital context with respect to section 12 subclause 2. Your Lordship, the very reason why such data is being used as according to the fact is to have a predictive analysis of what are the consumer behavior or consumer preference, but itself.
CCI has passed a prima facie order or final order?
Prima facie order.
So then you defend on the basis of the prima facie order. This is sounding like you've made up your mind. We can dismiss it on that ground also.
Yes, Your Lordship.
What are the grounds on which you can sustain a 226 remedy for a prima facie order?
For a prima facie order, whether it violates any fundamental rights, whether there was whether they have followed the statutory provisions, and is there a violation of principles of natural justice.
Are any of those made out?
No, Lordship.
Then that's it. That's all your argument has to be.
Yes, Your Lordship. I will proceed with my prayer. Wherefore, in the lights of facts of the case.